So thank you everything for being here and to stay until the end, I could say. Okay. Since the topic of my dissertation are concession and the extension of the concessions in for a special purpose, I decided to address the segment of the extension within the framework of OECD guidelines. Why? Because Croatia is a member state to enter the OECD. This is definitely a political question. It's an economic question, but in the end, it starts to be a legal question because the extension of the concession a legal question, and if we want to enter in the OECD, so we must also take the guidelines into the account. So what we will talk about, I will say some in the introduction about EU and international regulatory context that affects only concession extensions, about the OECD approach to the concession extension and some which are the key OECD principles, methodology for the extension, and I tried to make some simulation according to OECD toolkit and a conclusion. So let's start. So what is the OECD? We all know, just for remember, it's an organization for economic cooperation and development. It brings together more than 38 countries from Europe, North and South America and Pacific region. They took more than 80% of international trade, and the member states are perceiving as renewable and countries, and they're promoting the sustainable development and also the advanced legislative solutions. So it's every state wants to enter in the organization. So the Croatia, she is bringing the opinions to the OECD since 2012. In 2022, she received the candidate status. In 2024, it was signed the OECD agreement, and it's expected that the Croatia will become a member state in 2026. But until that, she must fulfill some obligations. This is the first part of the story. The second part of the story are the marinas, which are built during the 70s and 80s on Croatia coast, and mostly by today's concessionaires. In all that marinas, there are a huge number of entities. So, which they all have concluded business cooperation contract with the concessionaire. In Marina, where I worked before, we had almost 100 concluded business cooperation contracts. That's a huge number. So that's a huge entities, and the local who affects also on the local people. So when we are talking about first marinas on the Adriatic Sea, I took the article from Blue Highway or Plava Magistrala because the first categorization was made by Muko Bombardelli during 1970s. So so we have now the extension of concession in next few. We have the expiring of the concession in next few years, 5 to 10 years, and in the meantime came the regulation, came the Paris Climate Agreement that obliges the states to reduce greenhouse emissions. They don't say how; they just say to the member state that the companies must do it. Then came the European Green Deal, which aims for climate neutrality by 2050. Then we have the Fit for 55 package, because the companies must reduce emissions by 55% by 2030. We have fuel EU maritime regulations. We have the alternative fuel infrastructure regulation. And finally, we have the CSRD, which is the Corporate Sustainability Reporting Directive, because all Mostly all Croatians concessionaires are listed as SMEs, and the Corporate Sustainability Reporting Directive she requires from large companies and from listed SMEs to report about SDG standards. So these are environmental, social, and governance standards, and all this took a lot of money, and we have 5 years until or 10 until the concession will expire. So the concessionaire are asking, who will return me the money? The shareholders are asking, okay, you are investing our capital and our profit in some new regulations, and we will not see the dividend anymore. So this raises the questions: who will compensate these investments, or can the concession will be extended? So what OECD says, and what is his approach to the concession extension? OECD has numerous guidelines. They are soft law. They are not obligated for the member state. But if the Croatia wants to enter into the OECD, they are binding for Croatia. So I just put it here, the basic ones. It's the OECD basic elements on law and concession agreement. In this document, we can find how many processes we have. So I found that the OECD knows the auction, which also our Concession Act knows, but he also knows the negotiation and also knows the beauty contacts, which I didn't know. But if we took that it's similar to public procurement, and that the directive and the public the directive are siblings, then we see some similar elements. Then we have the OECD competition assessment toolkit. It mostly affects has some impact on the states to ask some questions where they are delivering the law. We have the OECD public-private partnership principles. The most important one, a Sigma brief, in which is implemented the directive on concession, and we have the OECD competitive neutrality toolkit. And he gives us the tool on which I made the simulation of the extension. So, which are principles of all these guidelines? That concessions should be allocated through transparent and competitive process. So they also said that repeated concessions with the same concessionaire may indicate that he had some privileged information and they can distort the competition. And that if we made the extensions, that they must be strictly limited, justified objectively, and by public interest, and published. So what also does it mean? We have also here the level playing field, which affects the hugest Croatian concessionaire, because it's a state majority owned company, and Croatia must take, when she will extend the concession to that concessionaire, she must ensure a level playing field for all other concessionaires, which are mostly private concessionaires. So in that case, Croatia in 2020, she brought the law on state-owned enterprises. What are the OECD tools for analysis? Sigma brief, he said that and clarifies that the modification of the extension are allowed only and strictly under Article 43 of the directive on the award of the concession contract. And if we go to the Article 43 and for the legal basis, shortly, what it say? It allows modification or the extension of the concession in specific cases in additional works or services necessary for technical or economic reasons, and for unforeseen circumstances changing the economic balance. So definitely we could say that the green investments like shoreside electricity, waste management, if we bring the hydrogen to the marina and etc. There are foreseen circumstances, and they are changing the economic balance between the concession grantor and the concessionaire. And on that side, I found some decisions from the Court of Justice of EU. The first one is that, and they are very important for the extension of concession for Croatian nautical tourism ports, that the modification must be made in the light of the union legislation, which is on force at the date of modification. So before we thought that modification can be made before contracts concluded or something like that, but that in the end is not possible. And the second one, it said that unforeseeable events can significantly affect the operational risk. So these are unforeseen circumstances. And the second opinion from Court of Justice is the German course. Is the German case, where on the German Autobahn, the operator decided to invest in plugging for electric vehicles, and the Court of Justice said that these are unforeseeable circumstances, and they said that the extension can be made. So when we took the OECD methodology for the extension, we have here 5 steps. So the first one, before screening, is definitely, for my opinion, ex-ante evaluation, because we must took the cost-benefit analysis and the stakeholder consultation. Then we must apply screening, which includes apply checklist to identify market distortion risks, analysis, in which we demonstrate necessity, transparency, and proportionality. Alternatives, explain if alternatives are not possible, why are not they possible, and in the end we bring the decision. So I tried to make one simulation, how that it looks like. So nautical tourism port, marina was built in 1970s on the basis of unlimited right of use of maritime domain, which through conversion and privatization was transformed into limited right in the form of a concession. The concession agreement was concluded in 1999 and runs until 2037. So investments of 10 million made. Then came the Paris Climate Agreement, European Green Deal, and the company is subject to the CSRD directive. So Croatia is candidate for the OECD membership, and in addition to EU directives, must also apply the OECD guidelines. Thus, the first question is, can the extension be granted on the basis of earlier concluded agreements? And the answer is found in the OECD Sigma brief, which says that the Article 43 must be applied, and it says into the cases in the light of the European Union when the modification is made. But are there possible exceptions? So OECD also said they are possible, but they strictly must be limited and they must be proved by public interest. I'm still dancing with a bear in this situation because I'm not quite sure for this answer. And the second question is, can the extension be granted on the basis of regulatory obligations? So I made here the toolkit. I used the toolkit. So I made a presentation. So the first step is that we took that we make the cost-benefit analysis, and if we decide to do that and to enter in that process, we are doing screening where we ask ourselves: does extension on the concession close the market? Does the privilege and concessionaire does it privilege the existing concessionaire? And is there objective public interest? So we took the risk assessment in every case and in every question that we ask. And so we can see that we can decide that there will not be the extension, we can give time-limited extension, and we can use the hybrid model, which would be short extension plus mandatory retender. And in this hybrid model, I'm searching and I read about right of first refusal. So if someone offers the same amount as so the state says to the existing concessionaire, okay, will you accept it? So if he accepted, he continues the concession. In other case, the concession will be given to another concessionaire. So when we took the analysis, we must ask ourselves, why is extension necessary? Is there a less restrictive measure? Is it appropriate, or is it open to others? Then we have the alternatives. Can the objective be achieved by retender? Can the hybrid solution be applied? And can the state co-finance SEG by maybe some, maybe they will give some money through some programs or something like that. And in the end, we are selecting the whole process, and we are asking ourselves which opinion is least distortive, is decision documented, public, and reviewable. So in this case, which I took, it says that recommendation short extension can be made for the SEG standards and for amortization, and then the mandatory retender must be done after. So what is the responsibility of the states? As I told, the OECD guidelines are not binding, but they carry significant weight. But if we see that Croatia she wants to enter and to be a member state, they are binding for Croatia. And for the end, conclusion is that concession extensions must be transparent, objectively justified, proportional, and competitive neutral. So, and green investments definitely are the base for the extension. And that's it. Thank you.